Officer Dave, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, Counsel.
Good morning, Your Honor.
What file do you have today?
This is Community Choice and Ward.
Community choice?
Yes, it's an objection to garnishment.
Oh, okay, I see. Got you. All right, put you back in the waiting room.
All right, thank you, Judge.
Hello,
Hello,
what is your name
my name is Julie Temrowski.
and why are you here?
I'm here to dispute a garnishment against my agency.
Are you an attorney licensed to practice law in the state of Michigan?
No, I'm a registered nurse.
Then you may not appear. Have your attorney appear.
Oh, okay. They didn't tell me that when I went down to the court building.
You may not appear in the absence of for someone else unless you are an attorney licensed to practice law in the state of Michigan.
Well, the garnishment is
Ma'am, I'm
against
not
me.
arguing. You're not
Oh, I
here.
know that.
You're not
I'm
here.
sorry.
You are not permitted to appear for another entity, whether that's a legal entity or another person, unless you are a lawyer. And since you are not, you may not appear. I'll remove you now. Hello? Hello?
Hello, good morning, Your Honor.
What is your name?
Gary Ward.
All right, Mr. Ward, hang on, we can get you started.
Yes, sir.
All right, we are on the record. This is file number 10128-753, Community Choice Credit Union versus Gary Ward. Date and time for objection to garnishment, your appearances.
Your Honor, Michael T. Mamet, PA 1102 on behalf of plaintiff.
And your name, sir?
And Your Honor, Gary Ward representing himself.
You are the moving party. What is the basis of your objection to garnishment?
My objection to this garnishment is based on the only income in my house is Social Security. And what they took was my Social Security money. And that's my objection. I can show that actually what happened was I had my house paid off at the beginning of the year. My wife and I are both on Social Security. She's disabled and incapacitated, so I take care of her on a daily basis. Back in January, we got our house paid off. I was able to rearrange my insurance so that I can do it monthly because I had to escrow through the mortgage. I talked with my banker and they suggested that I open up a savings account to keep my money for my taxes. And we did that and we started putting money in every month, which I can prove came out of my checking account from my Social Security, which is the only income. And that's what they compensated, was the money that I had set aside to cover my taxes.
Okay, Mr. Mamet.
Your Honor, as much as I feel for the defendant, he's failed to provide any real evidence that these funds are exempt. So I would ask the court, one, deny his objection, or in the alternative, simply adjourn this matter 30 days, order the defendant to provide me and the court with his banking records, showing the only thing going into these accounts are in fact Social Security or disability or another exempt fund.
Now, what I
Okay,
heard,
I have that. I have a whole year here for checking and for savings, showing all that transaction.
let me make sure I understand what you said. Where does your your wife's social security goes where? To
In
the
my
bank
checking,
check? Your
in my
checking
checking.
account.
Yes, both do.
Your social security old age pension goes where?
In my checking account.
And what was garnished was a savings account?
Yes, what happened was I had my house paid off, my taxes and my insurance used to be in escrow. I had my house paid off in January. And I talked with my banker and they told me that I could attach a savings account to keep that money separate to pay my taxes, and that it had the same protection as because it was attached to my checking account, it had the same protection. Now,
Mr. Mammon,
No, Your Honor, after he clarified, I believe what the court was looking for, the defendant unfortunately admitted to on the record. Once those funds are moved, they are no longer exempt. They're considered either commingled or completely up for grabs once they're in that savings account removed from the checking account.
yeah, I think that's what the law is.
well,
Your objection
Your
to
Honor,
garnishment, sir, is going to be denied.
well, Your Honor, may I say
Excuse
one
me, don't
thing?
interrupt me.
I'm sorry, Your Honor.
I'll let you speak without interruption.
Yes,
You
yes,
should
Your
give me
Honor.
the same courtesy.
Yes, Your Honor.
I think Mr. Mammoth's understanding of the law is consistent with mine. If this money was taken out of the checking account where there had been nothing but the social security income, disability, and old age, that's one thing. But you say it's in a different account. And for that reason, the court is going to deny your objection to garnishment. You have an absolute right to appeal my decision, and appeal must be perfected in 21 days of today in the Wayne County Circuit Court. Court will send out to both of you today in order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you, Your Honor. Is there any opportunity I could get a breakout room with the defendant briefly?
Yeah, you can do that. Hang on, let me put you in there. Assuming I can make this work.
Thank you, Judge.
Always, sometimes the technology doesn't always do what it wants to do.
Oh, no, I can appreciate that, especially
All right.
these last few days.
All right, let's put her in room 6. Patrol in room 6.
Thank you, Judge.
Okay. Hello? What is your name?
Tanisha Smith.
Arnisha Smith?
Tanisha.
Tanisha Smith?
Yes.
Could you, I believe I have Mr. Cox here. All right, this is case number 161149997, Oakland Community College versus Tanisha Smith. Could I have your appearances, please?
Yes, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
And what is your name, ma'am?
Tanisha Smith.
All right. We have a motion here today to compel return of funds. This is your motion, Ms. Smith. Why would the funds be returned?
Because in the last motion, you applied that they return all the funds immediately. And
How much have
then
you
when,
paid on the judgment, ma'am?
no, I haven't paid on the judgment yet.
You haven't paid the judgment off?
No,
Then why would the funds be returned, ma'am? I'm confused.
because they weren't supposed to be taking the funds. First of all, I didn't know anything about the judgment until it started coming out of my check. I never received any paperwork or anything because they were sending it to an old address. And then with this, I thought I had taken care of it with the student forgiveness loan and everything. So when I first started with this, they were garnishing my check in 2016. I filed bankruptcy and then with the student forgiveness, I thought that this was all involved in that. I don't have the paperwork.
Well, ma'am, student loans are not dischargeable in bankruptcy. They used to be, but they're not now.
But this wasn't a part of a student loan, so they said.
Okay,
They
so
said that
so it wasn't discharged in bankruptcy. Then I'm still not understanding, ma'am.
because I thought it was. They said that it wasn't right. They said it couldn't go on the student loan because it was. I mean, it's not a student loan. This was something that I bought from a gift shop or something like that. I really don't know what it is. I really don't. And all I was asking was for them to send me some paperwork. Now I called that office. Now I'm receiving paperwork. Now I'm receiving stuff about the case. Now he's sending me paperwork with finally, just now, after all the time. Now I understand what the paperwork is. But at the beginning, I didn't know what this was. I didn't know what it was about. I kept trying to get it taken care of. I couldn't get it in the bankruptcy because I thought it was student loan. I mean, I couldn't get it in the forgiveness because I thought it was a student loan. And then they said it wasn't a student loan. It was something I got from the gift shop or something like that in the school.
Mr. Cox.
Yeah, Judge, I think this is a simpler motion than what we're talking about. The defendant did have an installment payment order entered by this court, and the garnishment that was supposed to be shut off continued, and additional monies came out of her paycheck. And there was an objection to garnishment hearing. The court ordered the monies to be returned. We've mailed her a check for $1,066.74. And so I guess the real question I have for Ms. Smith is whether or not she received those monies, because if she has, I think the motion is moot, or the relief she's been seeking has been granted.
Been granted. Did you get the check, ma'am?
Yes, I got the check.
Okay. Well, that was the court's order, that because you had an order for installment payments, your wages should not be garnished. And if they return the funds that they garnished, then the motion is moot. So you still have the installment payment order, which, as long as you pay for it, as ordered, will protect your wages from garnishment. So the court's going to, Mr. Cox?
Yeah, I had one question, Judge. Plaintiff never got a copy of the order that the court entered. We know from the Register of Actions that one was in fact entered, but what is not clear to the plaintiff is the terms of the order, in terms of the date of first payment and the amount that she was ordered to pay monthly. And so.
What are you talking about? The installment payment order you don't have?
Yeah, Judge.
So you kept half the money. So you said that was for my installment payments that was supposed to be started. You kept $1,000, and you said, and that was to cover some of the months. And so all I wanted was to go to court to understand where I stood. I have came out of a lot of money, and then I don't get my money back. You didn't return all the money. $2,000 have been taken from me. Over $2,000 been taken from me. You returned $1,069, but you said you kept some of the money for some of the payments that should have been started for my monthly payments. I was just confused as to where my money went, how much I'm paying. I already been paying on this loan. A long time ago, I paid over $1,600 on this same $5,000.
All right, let's stop right
So
here.
I'm just not understanding where I stand on how I
Okay,
keep paying money and it's not going down.
Let me see if I can help you. On November the 18th, the court entered an order for installment payments, providing for payments in the amount of $50 every 2 weeks to begin January 1st, 2023. The court order also suspended the writ for periodic payments that had been issued on October 14th, 2022. So you are supposed to be paying $50 every 2 weeks. The judgment that was entered against you was entered on September 22nd, 2016, in the amount of $6,121. So that is, here we are in 2023, so you're now 7 years into that judgment. That judgment obviously would be garnering interest during that time period. So what I'm going to do, since you have received the funds back as ordered by the court, your motion is going to be denied. I will send to Mr. Cox a copy of the order for installment payments. Your motion is denied as moot, the funds having been returned. Anything else?
Not from planning.
That's
Commission.
not-
All right, thank you both for coming in. We're off the record.
Thank you, Judge.
Hello,
What is your name?
Tiffany Hawkins.
All right, hold on, we can get you started.
Okay, thank you.
08. We are on the record calling file 08-128-914, Modern Financial Services versus Tiffany Hawkins. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Now Jack Francis, P72322 on behalf of plaintiff's attorney of record.
And what is your name, ma'am?
Tiffany Hawkins.
You are the moving party. What is the basis of your objection to garnishment?
Since 2008, they have been garnishing my taxes for the car. The car payments have been paid, a few payments, and then the rest of the years through 2008, 9, 10, 11, 12, 13, 14, all the way up until 18, matter of fact, 19 on this paper. They've been garnishing my taxes. Garnish fees has been paid, and I'm trying to figure out why they're still trying to garnish.
How much money have you paid on this judgment, ma'am?
The judgment was paid, was
No, ma'am.
$3,900.
How much money have you paid on the judgment, ma'am?
$3,921.32 is
You paid a total of $3,900, is that correct?
correct.
Okay,
And not including the garnishment of my taxes yearly from 2008, from 2019. So the car has been paid for already.
what is the total amount of money, ma'am, you say you have paid on this judgment? Is that the $3,900 you just talked about?
Correct.
Okay, Ms. Francis, your response.
Your Honor, the current balance on the judgment is $7,705.64. That includes all of the payments that have been received from defendant through garnishments. This judgment is many, many years old, and interest has accrued, which defendant has not calculated into her calculation of the total. So her objections are invalid, Your Honor.
What is your interest rate on the judgment, counsel?
13%, Your Honor.
Okay. All right, let me go over to what the register of action teaches us, Ms. Hawkins, on this file. The judgment was entered against you on December 1st, 2008 in the amount of $4,078.82, which means that by what you say, you have not paid the amount of the judgment itself. However, that judgment earns interest like a credit card that is unpaid. And at 13%, that means it's earning $407 a month in interest, 1% of the $4,078 every month. So
That's understood.
the case,
That's very understood.
the matter was then removed, judgment was renewed again on November 29th of 2018. So if I take $4,000 1% a month, oops, got it wrong. Let me try it again. That's $40 a month.
Okay, so do the garnishment of the income tax, that does not include the payments, or is that just something that they do?
No, ma'am, that's not what I'm saying. What I'm saying is that this judgment, if you use the rule of 72, which is that a judgment doubles or every 6 years at 13%, this judgment has doubled, more than doubled, because it's more than 16, more than 72, the rule of 6 years. So you say you've paid an amount that is less than the amount of the judgment back in 2008. That was what you told us. You failed,
Correct.
man.
So what I'm trying to understand is from the payment that I paid, plus the interest that was occurred to the account, plus the garnishment from the taxes from that day to this day, that's not included as far as payment, or is just where is the money going is what I'm trying to understand. You're garnishing the taxes, but where is the money going? It's not applied to the interest. Is it applied to paying for the rest of the fees? That's what I'm trying to understand here.
Ma'am, what you have told me is that you have paid $3,900 and change on a judgment of $4,078 that is from 2008. That $4,000, excuse me. All right, thank you. Okay, I'm not gonna argue with you about it. This is what the court finds. The court finds, based on the testimony or the statement, excuse me, no under oath testimony hadn't been had, based on the statement of the defendant, that she has paid less than the amount of the original judgment, a judgment that was entered in 2008. That judgment is bearing interest at 13% or more than 1% a month. The objection to garnishment is therefore denied. You have an absolute right, ma'am, to appeal my decision. That appeal will be perfected within 21 days of today in the Wayne County Circuit Court. We're off the record.
Thank you, Your Honor.
Anything else, Ms. Francis?
No, Your Honor.
Mr. Ruza,
Hello, Judge. How are you?
I'm well. How are you?
Oh, not too bad today.
This is file number 191788871. Credit Acceptance Corporation versus Garnishee. Defendant here is Temrosky Elder Care. This is the objection to garnishment. Earlier today, once we went in session, and I was attempting to find out who the persons were who had checked in, a person checked in for Temrosky Elder Care. This person described themselves as not a nurse, not a lawyer. I advised this individual, who I believe the last name was Temrosky, that she could not appear on behalf of another entity unless she was a licensed lawyer.
Yes.
I then removed her. So I was going to wait to give them 10:30 to see whether their lawyer appeared. But right now,
I will do whatever you want, Judge. I have how we call chamber work to do in my office.
okay,
I can be around as much as you want.
I'm going to give them till 10:30 because she had time to call a lawyer and have the lawyer come in. But a nurse cannot appear on behalf of a corporate defendant. It's just that simple. So,
All right. So I will wait.
Yep, and I'll get back to you soon.
Thank you, Judge.
Mr. Weberman,
Good morning.
good morning.
Yeah, Mr. Hill, me and Mr. Hill both were on at 9. I believe there was initially scheduled at 9 and was rescheduled and there's some confusion. So Mr. Hill stated that he had an appointment and couldn't stay on, I believe.
Well,
But I just wanted to acknowledge the court.
Let me stop and call the case and we can hear from you, okay?
All right.
This is 21-169-227. HS Financial Group versus Jimmy Hill. This is date and time for a motion for an order to show cause. Your appearance.
Good morning, Your Honor. Daniel Weberman, P76609, on behalf of the plaintiff.
Mr. Weberman, this file was reassigned from Judge Giles' docket to mine. When that reassignment took place, we changed the time of the hearing from 9 o'clock to 10 o'clock, because I do my objections to garnishment at 10 o'clock. We had earlier divided among us civil judges, some doing them at 9, some doing at 10. So you say that Mr. Hill came on earlier and said he could not appear to stay. Is that what you said?
Yes, Your Honor. I had it on my calendar as at 10, but this morning, obviously, I pulled up the old notice to see if he had appeared. I came on at 9, and obviously the court wasn't here. He was here, and we talked briefly. He stated he had a doctor's appointment at 10:30.
Okay.
And I stated I would let the court know because he did appear, but obviously he didn't receive notice of the new time. So.
All right, because the court mailed out notice of the new time to all the parties. Well, what I'll do then, Mr. Dovers, I'm sorry, Mr. Weberman, I'll just adjourn this matter for 2 weeks. So
That would be appreciated. Thank you very much.
let me get my calendar out here and figure out 2 weeks from today. That's going to be March 15 at 10 o'clock. I'll send out an order.
All right. All right. Thank you very much. Have a good day.
Thank you. We are on the record. This is file number 19178-871, Credit Acceptance Corporation versus Tanisha Gatewood. We are here today for an objection to garnishment filed by garnishee defendant Temrosky Eldercare. Could I have your appearance?
Judge, may I please court? My name is Attorney Richard Grusom. My bar number 35222. I'm the attorney of record for the plaintiff, and today I am the respondent to the garnishee defendant's objection to a bank garnishment.
All right. The record should reflect that before Mr. Rusin appeared, when I was attempting to check into people in my waiting room, there are people who appear by telephone numbers and I don't know who they are. So the only way I can find out who they are is to invite them into the main session and get their identity. When I was doing that, an individual who described herself as a nurse and specifically denied being a state licensed attorney advised that she was appearing on behalf of Temrosky Eldercare. I told her that unless she was an attorney licensed to practice law in Michigan, she could not appear on behalf of the Eldercare of another entity. I then removed her. She has not had counsel contact us. It's now after 10:30. The objection to garnishment is going to be denied. I will note for the record that the garnishee defendant failed to appear by counsel.
Thank you, Judge. On that, plaintiff rests.
Easy day, Mr. Rusin. Have a good day.
Thank you, Judge.
You're off the record. That concludes the morning call.